Hello, my name is Isabel and today I'll be presenting on the interaction between AI and copyright, specifically whether existing doctrines of authorship and originality can accommodate works generated by artificial intelligence. AI systems like ChatGPT can mimic creative works, but they lack intention, judgment, and personality. Copyright assumes creativity comes from a human mind, so this raises the tension about whether existing authorship rules can stretch to cover AI-generated outputs. Argument 1 asks whether existing doctrines of authorship can accommodate AI-generated works. Copyright has always assumed a human author, someone exercising intellectual effort, judgment, and personal expression, and across all major frameworks, authorship is explicitly human-centered. Starting with the Berne Convention, Ghaffar and Al-Bashadi, in their 2025 article Copyright Protection for AI-Generated Works in the Asian Journal of International Law, explain that Berne requires creativity attributable to an author and its mechanisms. Attribution, identification, and moral rights all presuppose a human creator. Although Berne does not define author, the context shows it refers to natural persons or legal entities deriving from them, not autonomous AI systems. The European Union follows the same logic. The Court of Justice in the European Union's originality standard requires the author's own intellectual creation. In Infopack International vs. Danske Dagbladet Forening, originality is tied to human selection and arrangement of elements. In Paneer v Standard Verlags GmbH, the court held that originality reflects the author's personality, even when technical tools are used. Ghaffar and Al-Bashadi also note that Article 6 of the Directives 93/98 EEC and 2006/116 EC confirms that only human creations qualify for protection. The academic consensus reinforces this copyright doctrine that is built on human intention and creative personality, qualities AI systems do not possess. So AI-generated outputs fall outside existing doctrinal boundaries of authorship, and current copyright law cannot accommodate them without reform. Argument 2 considers whether AI-generated works can satisfy the originality requirement. Originality is a distinct threshold, and the key issue is whether it can be met without human creative input. Ghaffar and Al-Bashadi 2025 make clear that originality requires creativity attributable to an author, and that copyright protects works because they embody the author's intellectual effort and creative personality. This structure presupposes a human mind capable of intention, judgment, and aesthetic decision-making. AI systems do not possess these qualities. They generate outputs through statistical modeling and pattern recognition, not through personal creative choices. Jenny Kwong, in her 2021 article, Does Training AI Violate Copyright Law?, reinforces this idea. She explains that machine learning models do not engage with expressive creativity. Training simply extracts unprotectable ideas and patterns for functional purposes. Copyright law draws a strict line between creative expression and ideas. AI operates entirely on the idea level, not the expressive level originality protects. So even when AI outputs appear creative, the creativity is stimulated, not the product of human intellectual effort. As Ghaffar and Al-Bashadi note, the law has no mechanism to recognise such outputs because originality is tied to human creativity. Therefore, under existing doctrine, AI-generated works cannot satisfy the originality requirement. Argument 3 addresses ownership, the final gateway to copyright protection. Even if AI-generated outputs fail on authorship and originality, we must still ask whether ownership could vest under existing law. As Ghaffar and Al-Bashadi in 2025 explain, copyright ownership flows from authorship. The law links ownership to the individual who creates that work, pre-proposing a human capable of holding and exercising right. AI systems cannot meet this requirement. The UK is essential because it uniquely provides for computer-generated works under Section 9, Subsection 3 CDPA. The UK IPO's Copyright and AI consultation in 2024 confirms that where a work is generated, Without a human author, the author is the person making the necessary arrangements. Yet the consultation identifies two major flaws. First, Section 9 applies only to the original LDMA works, but the modern originality test, requiring an author's own intellectual creation and human personal touch, is inherently human. This creates doctrinal contradiction and uncertainty about its interpretation. Secondly, the government found almost no evidence of real-world reliance. Respondents in 2021 claimed to use the provision, but offered no examples, suggesting it may not function effectively in practice. We will now be comparing the jurisdiction approaches. In the UK, the IPO's Copyright and AI Consultation 2024 identifies two problems with Section 9, subsection 3 CDPA. It presupposes originality, yet the CJEU's author's own intellectual creation test is inherently human, and there is almost no evidence of real-world reliance. Respondents in 2021 gave no concrete examples of this. The EU position is clearer. In InfoPack International versus Danske Dagblad Forening and the key case Payne v Standard Verlags, the CJEU held that originality requires human creative choices, and Article 6 of Directives 93/98 EEC and 2006/116 EC limits protection to human creations. The US Copyright Office also requires human authorship, so across all three systems, AI-generated works fall outside the existing copyright law. The UK's IPO Copyright and AI Consultation 2024 highlights growing misalignment between copyright law and AI development. It stresses the need for scalable, collective licensing while CMOs already license large volumes efficiently. AI developers, especially smaller firms, require simplest access routes, and the consultation notes that new structures may be needed for data aggregation. It then revisits Section 9, subsection 3 CDPA, confirming that it applies only to the original LDMA rather than the creation test. It is inherently human, creating significant interpretive uncertainty. The government again reports minimal real-world reliance. Respondents in 2021 claimed to use Section 9, subsection 3, but provided no clear examples. With generative AI now widespread, the consultation considers it timely to reassess whether AI-generated outputs should attract protection at all. Overall, it reflects a dual concern, enabling lawful AI innovation while addressing instability at the heart of the UK's computer-generated work regime. A key question is whether the law should distinguish between AI-assisted and AI-generated works. AI-assisted works involve meaningful human creative input, selecting, arranging, or editing AI-produced material, and under the CJEU's originality standard, in InfoPack International vs. Danske Dagblad Forening and Payne v Standard Verlags, these works remain protectable because they still reflect the author's own intellectual creation. The US Copyright Office adopts the same approach. AI elements are acceptable where a human contributes expressive creativity. AI-generated works, by contrast, are produced autonomously without human intention or judgment. As Ghaffar and El-Bashadi 2025 in their article argue, both authorship and originality presuppose human creative personality, which AI systems lack. The UK IPO Consultation 2024 reinforces this, highlighting instability within Section 9, which requires computer-generated works to be original, despite originality being defined in human terms. So, the emerging consensus is that AI-assisted works remain protectable, while fully autonomous AI-generated outputs fall outside existing doctrine, and reform should codify this distinction. Some scholars argue that copyright can already accommodate AI-involved creation. A key example is Johannes Fritz in his article JIPLP 2025, which suggests that in AI-assisted works, humans still make meaningful creative choices, selecting prompts, curating outputs, or editing results, and that these decisions can ground authorship. But these views apply only to the AI-assisted works. It does not resolve the doctrinal problems posed by fully autonomous AI-generated outputs, which lack the human intention and creative personality required for authorship or originality under existing law. To conclude, existing copyright doctrines are fundamentally human-centered. Authorship, originality, and ownership all presuppose human intention and creative judgment, meaning fully autonomous AI-generated works fall outside the current framework. Across the UK, EU, and US, the position is consistent. AI-assisted works remain protectable, but AI-generated outputs do not. Reform is therefore needed to codify this distinction clearly.